I think it's the heights of negligence and poor governance that a bill of this nature, so complex and far-reaching, is being brought to the House on the 28th of March, when the government says it's facing a deadline of the 31st of March for its passage. That is chaka-chaka government. I'm very disheartened by what we are being asked to do. I have not had an opportunity to review this thoroughly. It deserves a thorough review. I'm not alone in this. I'm going to read you an email I just received from one of the leading company law practitioners in the country. They say, as practitioners in this area, they are alarmed that this will come into effect with all the far-reaching changes without even a transition period. And they make the point that we are already overwhelmed with the TCSPA, which is the Trustee and Corporate Services Providers Act, and the onerous and numerous requirements now that this one will give no chance to cross over. And she asked me to make representation. This is a problematic approach that we're taking here. The Act, Clause 1, does not have a provision for the minister to bring it into effect at a future date. It comes into effect once it is, the GG gives assent, which presumably they're going to try and do before this cutoff period of March the 31st. I don't know if that will be achieved. And then the notice of the passage of the bill has to be gazetted. So there's no transitional provision. I have been told by reliable sources that within the Registrar of Companies office, there are major concerns that they are not ready for the implementation of this bill and they need a transitional period before they can operationalize this act. I would ask fervently that the minister accede to an amendment to Clause 1 to provide the usual provision that it will come into effect on a date determined by the minister by notice, or whatever the proper drafting language for that is. In FATF cannot force Jamaica to pass laws which have not been properly reviewed by our legislators. It's a dereliction of duty on our part to let that happen. None of us in here fully understand what's in this, and I would venture to say 99% of us have no clue what's in here. It is a poor and unfortunate way of proceeding. In my somewhat cursory review of it, I have some concerns. First of all, the absence of a provision that allows it to be brought into effect at a later date. In that interregnum, practitioners could digest this properly and see to what extent it may require fixing. And those fixes could be quickly drafted so that an amending bill could be brought, so that when it is brought into effect, it has been fixed before that date. That could be done. The Companies Office of Jamaica could go through the necessary training and other necessary internal processes to make them ready for its implementation and operationalization, which they have not done, I am told. It is very important that that be remedied. Clause 4 of the bill says that no company incorporated under this act shall have a nominee shareholder. It doesn't say what a nominee shareholder is. It's not a defined term in the Act, the Principal Act. Madam Speaker, the vast majority of companies in Jamaica are incorporated by persons in the office of the attorney or other firm that's incorporating them, signing the articles of incorporation. They do so as a nominee for the client, and that is subsequently rectified thereafter. I don't know how many companies are going to be immediately in breach of this. There's no provision for it to a period of time to fix it. And in fact, one has to question why it's even in here. What this act is primarily about, these reams of pages, are about disclosure of beneficial ownership of shares. So if you have to disclose beneficial ownership, right up the chain, then why can't you have a nominee shareholder? Because the whole essence of a nominee shareholder is that the shares are held by A on behalf of B, and B is a beneficial owner. It is a question of commercial convenience that these arrangements be facilitated. It is going to be extremely inconvenient to require subscribers to be the persons who are beneficial owners when you're incorporating. The clients may be all over the world or all over Jamaica. So I don't understand why this is necessary. It doesn't seem to me to make sense to do it this way. In Clause 7, it talks about what the Register of Members, this is an amendment to Section 109 of the Principal Act, which deals with the Register of Members. And it talks about what particulars have to be included in the Register of Members, and it's a much more extensive thing than it used to be. I'm not seeing anything that excludes public companies from this provision. There's an exclusion of public companies from amendments to the Register of Members. If you amend the Register of Members, you have to notify the registrar, and you have to produce details as to the amendment to the register. And there's a provision, a new subsection 4, which says that that requirement of any change in the particulars of who is in the register as the owners of the shares does not apply in relation to membership of a public company. I can understand why. Public companies have thousands of shareholders typically, and they trade on an exchange. And trading takes place every day. It's not practical to comply with this regime in relation to public companies. But there's nothing in here that speaks to the register when it is initially set up. Only deals with changes to it. So I don't know how that will work. If you take a company public, you have an IPO like we've had with Wigton or Trans-Jamaican Highway. God knows how many shareholders subscribe for shares in Trans-Jamaican Highway when it went public. Are we going to have to comply with this in relation to the register for that? And indeed, where shares are held in the depository, the Jamaica Central Securities Depository, which the vast majority of them will be, because you have to be in the depository to trade the shares. How is that being addressed in here? I don't know. There were regulations that addressed that in the past. I'm not seeing those being amended. So I don't know how that will work. The minister said how important this bill is because it ensures sanctions for breach, but there are no sanctions for the breach of that provision. The Clause 4 inserts a new Section 23A into the Act, which is one very brief provision with it's not made an offense or anything. That says no company incorporated under this Act shall have a nominee shareholder. There are no consequences outlined for breaching that. So the implications of this are half-baked and are not clear. But I'm going to move now to Clause 17 of the bill, amending Section 172 of the Principal Act, the Companies Act. And it inserts a new subsection 1A, and that says, no company incorporated under this Act shall appoint a nominee director. Again, what is a nominee director? That is even more obtuse than the concept of a nominee shareholder. And at least a nominee shareholder is fairly well understood as meaning a situation in which A holds shares on behalf of B, whether as an agent or a trustee. But a nominee director is a novel concept. The Companies Act has a concept of shadow directors. That is not what is being employed here. And if you're a director of a company in Jamaica, you owe the statutory duty of care to the members of the company, regardless of whether you think you represent anybody or not. Your duties under the law are owed to the company and its members. That is in our Companies Act. And then there are fiduciary obligations that you owe of a variety. You can't profit out of the company's business personally. You can't enter into contracts which create a conflict of interest unless you disclose them. There's a whole litany of obligations that apply to all directors. I don't understand this concept of nominee directors. It's not defined, and it says you can't appoint one. What is one? What is a nominee director? In Clause 23, and this is now inserting a new Section 363B into the Act. And this is in Part 10. Part 10 is the sectional or the clutch of sections in the Companies Act that deals with overseas companies that register here to do business. They're not Jamaican companies. They're incorporated abroad, but they're establishing business here, typically through a branch. And if they have a place of business in Jamaica, they have to register under Part 10. Again, it says that no company to which Part 10 applies shall have a nominee shareholder or nominee director. So we are now telling companies that are incorporated abroad and that may be empowered and authorized under their law to have nominee shareholders, that they can't do so if they want to come to Jamaica. And they can't appoint this concept of a nominee director. I am sure that when this is properly digested by practitioners, they are going to have many other concerns about it. And I just feel that we are going down the wrong path when you bring legislation like this to Parliament and say, just pass it. No matter what it says. Just trust that it's good. Trust that it works, that it's cohesive, and pass it. There's not even a period of time before it's brought into effect, which is quite normal in our law. You know, a year or so ago, the minister brought a piece of legislation here, I think it was in a hurry too, to amend the Trust and Corporate Services Providers Act. That act was one of the pieces of legislation that was enacted to establish Jamaica as an international financial center. This is under Bruce Golding's government. This was their policy. They passed the JIFSA Act, the Jamaica International Financial Services Authority Act, which was a regulatory body established by law that was going to oversee Jamaica's foray into becoming an international financial center. And that then required a whole load of other pieces of legislation to be passed so that Jamaica could get into that business. And we were told at the time that it was a game changer and we were going to be very successful with it and so on. We were skeptical about it. We didn't really see Jamaica as being a prime candidate for that type of business for a variety of reasons. Nevertheless, such a lot of work had been done that when we came into office, there was a number of incomplete things to be done, and I personally spent quite a bit of time trying to move it along. But the Trust and Corporate Service Providers Act was to provide a new industry of persons who would service the International Financial Center, so that they would be the ones who would form the companies, set up the trust, administer the companies for this offshore business that we were going to do. Which has not, as it turns out, that's going nowhere. But it's, you know, that act was passed. Then because of this whole grey listing thing, the minister brought an amendment to that. That amendment had an extensive set of penal provisions in it. This is an offense, that is an offense, third is an offense. It was really a penal piece of legislation. And it was because money laundering and terrorism financing risks are associated with international financial centers, so we were under scrutiny, and so we had to amend what had been passed before. There was no mention in this House or in the Senate at the time that the implications of the amendments that were being passed a year ago was that the legal profession, among others, would now have to apply for licenses to be regulated by the Financial Services Commission, the FSC, in order to do basic legal business. Basic legal business, forming companies for people, drafting wills for people, handling estates, where you apply for probate, getting the assets, and distribute them in accordance with the will. So now the entire legal profession is in a bit of a tizzy because they've been written to by the FSC with a deadline for applying for licensing. They have to have an extensive business plan as to how they're going to operate as a corporate service provider or trust service provider. That is entailing significant costs. There are all the fees that have to be paid to apply and no doubt to continue once you're licensed. And this is to do business that lawyers have been doing for years. Basic legal work. None of us in here had any inclination that this was going to be the effect of amending that act the way it was done. And yet that's where we are today. So I'm very wary of doing it again, of passing this thing blindfolded, so to speak, you know, on a whim and a prayer, because we want to get off the grey list. We've been on the grey list for a while. We want to get off the grey list, but let's do it in a sensible way, in a way that is prudent, and not in a way that doesn't involve us acting in dereliction of our duty as legislators to know what we're passing, to scrutinize it appropriately. So, Madam Speaker, of course, the attorneys are now regulated under POCA. We had passed that. We had initiated that when we were in government because it was necessary, because attorneys handle clients' funds in large volumes and do transactions that they must know the source of funds and ensure that they're not facilitating money laundering. That was contested by the bar, and they took it, the matter went all the way up to the Privy Council. The Privy Council ruled that what was done was lawful. And so the profession now has to start complying with the guidelines prepared by the General Legal Counsel as a regulator of the legal profession in relation to most of non-contentious business, what lawyers call non-contentious business, business outside the court. So the legal profession has a new regime they're now having to comply with, which ought to have been implemented a few years ago, but because it was being challenged in court, it wasn't until the Privy Council ruled a month or so ago that now they have to comply. And they have to now refresh the training that they, you know, everybody in the firm has to understand what the requirements are. You have to have a responsible officer appointed, somebody who's willing to take on that role. And not everybody is going to be too inclined to do that. So they have a lot on their plate. All of a sudden now, FSC saying they must be regulated, the lawyers must be regulated by the FSC to form companies for people, to draft wills for people and administer estates. But let us not proceed, you know, with haste that makes waste.